Hi, everyone. Thanks for joining us today. The webinar is about who will speak for you, choosing the right agents for your future. And truthfully, this is a topic that people put off thinking that they have the time. But you can't predict an accident, illness, decline in capacity. So truly, everyone 18 years and older should be thinking about this. If you put the correct documents in place, you can decide ahead of time who can manage your money, who can speak with your doctors, who can make healthcare decisions for you. By thinking about these things and making the decisions now, it reduces the stress and confusion for your family. Once you've thought about who you want to name as your decision makers, you need a complete estate plan. Your estate plan will answer the questions: what happens that if you cannot make decisions? Who can act on your behalf? What medical care would you want? And what happens to your assets when you pass away? By having all of these answers, all of these questions answered through your estate plan, it makes everything easier for your family. A complete estate plan includes more than just a will. A complete estate plan includes a financial power of attorney, healthcare power of attorney, a living will, which is sometimes combined in one document with the healthcare power of attorney, a last will and testament, sometimes a trust, depending on your specific situation, and beneficiary designations. Everyone always thinks of a will, of course, and while that is very important, just having a will alone does not protect you and your family. You need all of the documents that I just mentioned to appoint decision makers for during your lifetime, which are the financial power of attorney, healthcare power of attorney, and your living will. A financial power of attorney allows someone that you choose to manage financial and legal matters for you. This can include dealing with your bank accounts, paying bills, filing taxes, handling insurance, managing investments, signing contracts, buying or selling property. Um, Contracts can include, the admissions agreements for facilities or for hospitals, things like that as well. Without a financial power of attorney in place, your family is not able to access accounts or manage financial responsibilities if you become incapacitated. Your mortgage could go unpaid, insurance can lapse, property issues can become delayed. I tell people all the time, this is really one of the most important documents you can have. If you do not have a power of attorney and something happens to you, where you no longer have capacity to sign a document, the only option for your family is to get the court involved. The court process would be needed if someone's incapacitated and cannot sign documents. The court will appoint a guardian for the incapacitated person. This truly is like worst case scenario. I want people to avoid this at all costs. The ideal situation truly is to appoint someone now. So in the event of your incapacity, they can act without the court getting involved. A financial power of attorney document can be effective immediately, and that is pretty typical. Sometimes that's jarring for people depending on who they're appointing as their agent, but it makes it easier for your agents if you have a document that's effective and they can just jump right in without a doctor signing off and saying someone's incapacitated. However, if you truly don't have anyone that you want to have the ability to act on your behalf immediately, the document can be effective upon incapacity. The most important thing is to have a financial power of attorney document where you appoint these decision makers. Another document that's used during your lifetime is a healthcare power of attorney. This is where you appoint someone to make medical decisions for you, but only in the situation where you're unable to make your own medical decisions. So this is standby authority only. It's different than the financial power of attorney, which can be effective immediately. The person you appoint as your healthcare power of attorney is the person who would speak with your doctors, review medical information. They can consent to treatment if you're unable to do so. They will make care decisions for you, discuss rehabilitation or facility options, and they're your advocate. So it's really important for you to have conversations with your healthcare agents about the types of care you would want or not want so that they know your wishes and that they're able to make the same choice you would make if you're able to do so. Having a healthcare power of attorney is important because the medical decisions often need to be made quickly. It's critical to have a clear decision maker. If you don't have a healthcare power of attorney document, Pennsylvania law provides for who is able to make medical decisions for you and in what order, depending on the relationship. However, if you have a document and it's right there in black and white, who is the decision maker, it's much easier versus if the law provides that the children are able to make the decisions and there's five children, it's just a much more difficult situation. And sometimes you have multiple people of the same class, or there's family issues where them making decisions together is just not an effective. They're just not good at making decisions together because of different family issues. So it's much better to have clear decision makers in order of who you want to make those decisions. Without that, there are often delays, disagreements, confusion about your wishes, or difficulty communicating with the providers. A living will give guidance as to the medical care you would want or not want if you have an end stage medical condition and you're unable to express your own healthcare wishes. So, this only applies in the very limited situation where you are end stage, death is imminent and unavoidable, and medical treatment won't change the outcome. It addresses life-sustaining treatment, use of ventilators, tube feedings, and comfort care measures. When I go over this with clients, usually people have really strong feelings about the type of care they would want or not want if they are truly end stage. So having a living will that you've gone through, laid out your choices, it makes it a lot easier for your family members to just follow your wishes and instead of having to substitute their judgment for yours. It really takes the burden off of your family members. The difference between a healthcare power of attorney and living will, which I kind of just said, but a healthcare power of attorney is the person who can speak for you and make any medical decisions for you, not just end of life if you're unable to make your own medical decisions. Whereas the living will gives your healthcare agent guidance about what you would want in an end stage medical condition. So they're distinct. So you need them both, basically. They have distinct purposes. So it's really important that you have a healthcare power of attorney and also you've gone through a living will and made the choices about care you would want if you are end stage. The last will and testament is something else everybody needs. And again, this is what everyone's heard of. Everyone, knows they need a last will and testament. Often when people come in and they've done some estate planning, they have the will, but they don't have the other documents that go with it. The will lays out what happens to your assets after you pass away. It names your beneficiaries. It lists the people who you want to serve as executor, and it can also name guardians of your minor children. Without a will, of course, again, without the right documents, the chance of issues increases. There can be confusion, conflict between family members. If you don't have a will, Pennsylvania intestacy law decides who will inherit. Sometimes that actually works for some people. It might reflect your wishes, but so often it does not. Also, there could be other factors that you want to consider, whether a trust is appropriate for a beneficiary, or if you have a disabled beneficiary, that there's other planning techniques that we would use, but the intestacy law doesn't provide for that. So it's really not a great option to just rely on the intestacy laws. Every week, I just spoke to someone yesterday about this. I see clients who have been told that they need a trust from a family member, a friend, a neighbor, someone who knows someone who has a trust. Not everyone needs a trust. It is so fact specific, but they can be really useful depending on your situation. There are a few different types of trusts, but trust can help with centralized asset management, planning for incapacity, protecting beneficiaries in the event of creditors or divorce, special needs planning, and long-term proactive care planning. So there's definitely a time and place for the use of a trust, but it requires careful consideration of your assets and all of the facts specific to you and your family. Trusts, especially, are not a one size fit all approach. It just depends on your goals. Beneficiary designations, it's another part of your estate plan that I think is one of the most overlooked areas of estate planning. Some assets have passed by beneficiary designation and not by the will. These include life insurance, retirement accounts, annuities, and payable on death accounts. So often people will update their wills, but they don't confirm that their beneficiary designations match or make sense with their overall estate plan. And now, with so much of people's wealth being in their retirement accounts, that's why this part is so critical. For example, recently I was doing an estate administration where there was a will that was executed and provided a trust for one of the beneficiaries. It was a beautifully drafted trust under the will. The goal was that the assets would pass to the beneficiary inside this trust instead of to the beneficiary outright. However, when we went to actually administer the estate, the beneficiary designations on the IRA had not been updated to the name of the trust. So the beneficiary was just inheriting the IRA assets outright, which I do not believe was the intention of the testator. We didn't prepare that will, we were only administering the estate. But we do see that so often where they have this, there's this beautiful will that's done, but then they didn't consider all of the assets holistically. And so the intentions of the testator don't actually come to fruition because not everything was considered. So it's really important when you're doing your planning that it's complete and it's considering all of the assets, whether they're probate assets or non-probate assets. Like I said, all of the documents together make up a complete estate plan. During your lifetime, the financial power of attorney, healthcare power of attorney, and living will protect you and appoint decision makers. The power of attorney terminates upon your passing. So when someone passes away, their power of attorney can no longer act. So sometimes a power of attorney tries to use a bank account to pay for the funeral or pay expenses of death. But that power granted under that document terminates when the person passes away. And the power then shifts to the executor to pay the expenses of the estate. After you pass away, your will, your trust, and your beneficiary designations will distribute your assets to your intended beneficiaries. So it really is not enough to just have one or two of these documents. You really truly do need the complete set. So now that we've gone over what is needed, the tough part can be choosing your agents. The agent is the person who you choose and that you legally authorize to act on your behalf. That person is the person who's making financial decisions, healthcare decisions, and then there are other fiduciary roles, which include the trustee and the executor. It's important that you not only name the initial fiduciary, but that you also have backups in case the original person you name is unable to serve for whatever reason. And that you want to look at these documents. You don't want to just appoint these people and then forget it. I sometimes see people who they've appointed siblings. Well, now their siblings are, in their late 80s, 90s, they have dementia, they're in a nursing home. Things happen where you have to update these documents. So it's important to have a primary person and then also the successors. In choosing your financial agent, you really need to choose someone that you completely trust, as well as someone who's actually able to handle the job. The financial agent is always bound by a fiduciary duty to act in your best interest. Sometimes I have clients who want to list a child who's not good at handling their own finances, and they say, well, I'm just going to name that child so they don't feel bad. I don't want them to feel bad if I named their siblings. I so strongly advise against this for obvious reasons, but one thing to remember is that being named as an agent really isn't an honor, it's a responsibility. So it's important that you choose the right person for the job and not just to not hurt somebody's feelings. The qualities that you should look for when you're choosing your agent are obviously trustworthy. They should be organized. They need to keep records of the expenses that they pay, the bills that they pay. So they have to have the ability to keep all of those different records, responsible and obviously responsible with money. So you should think about that when you're choosing your financial agent. Like I already said, do not choose someone who's not equipped to handle the responsibility. Be cautious if you're naming someone who has financial issues themselves, such as being a spendthrift or has gambling issues, someone who's disorganized, or someone who just feels entitled to your assets. Because again, this person is bound by a fiduciary duty to act in your best interest, not thinking about what's in it for them. Once you pass away, you really want your assets to be able to be used for you and in your best interest. Oftentimes, when people are choosing agents, your healthcare agent is the same person you named as your financial agent, but that's not always the case. They're very different roles. So, someone who is not financially savvy could still be the perfect person to handle your medical decisions. Your healthcare agent only has the authority to make medical decisions if you are unable to make medical decisions yourself. So, this is standby authority only. This is different than the financial power of attorney, where I said it could be effective immediately. It's also important that your healthcare agent understand your wishes and not substitute their personal feelings for your wishes. I had an interesting call with a father and daughter. He was going to name her as his healthcare agent, and he wanted to discuss it with her before he did it because he knew that there might be things that they were at odds with. So when we had this conversation and he expressed to her what his wishes were, she expressed concern that his wishes were in direct conflict with her beliefs. So she didn't believe that she was the right person to serve as his agent. And I thought it was really interesting because she was able to recognize, even though this is what he wants, she did not believe she would be able to fulfill that role. So he ended up choosing another person to serve. But that right there is why you have these conversations now. Put everything on the table so the right agent can be chosen and everyone can feel comfortable. Even people who have these documents done and they've thought long and hard about who they're appointing as their agent, a lot of times they haven't had the conversations. They haven't talked to their kids, talked to their agent about the care, what they would actually want to have happen. So it's important that you discuss this with your agent and, keep them informed as things change. When you're deciding on a healthcare agent, some traits to consider when choosing are the ability to stay calm in a crisis, someone who asks good questions, someone who can handle the emotional decisions. I think most importantly, almost, is to choose someone who will respect your wishes. And then also, you want to think about how this person can communicate with other family members. A lot of times, a parent has one child serving as healthcare power of attorney, but they want their other children to be kept informed. So you really want to make sure your healthcare agent has the ability and the relationships with other family members that they could do that. Like I said a few minutes ago, sometimes a financial power of attorney and healthcare power of attorney are the same person. That's pretty typical, but sometimes they're not. So carefully, consider your choice for each role. Now, a question that often comes up is, should I have co-agents or multiple agents? Do I need a successor? Co-agents are when you have two or more people serving at the same time. This is completely fine. It depends on their working relationship, though. You want to choose people who can work well together, and you don't want it to be more stressful having two people who can't work well together trying to make decisions for you. I had a client, this was years ago now, but it sticks with me because he was naming his two children as co-agents on every single document, as executor, as healthcare power of attorney, as financial power of attorney. So I was assuming as we were going through and he's telling me this that they got along well. And so finally I confirmed that with him. I said, "Well, how do they get along?" And he told me that they are actually estranged and haven't spoken in 15 years. This was his plan to get them talking again, to name them as co-agents on everything. He did not do that. I can't stress enough what a bad idea that is. If people are already on bad terms, putting them as co-agents in a stressful situation where they need to step in and act as financial power of attorney or healthcare power of attorney is not a good option. To name co-agents, it's critical that they have a good working relationship. We often do see co-agency with siblings who get along well and have no issues. And in fact, this can be very helpful. When people are naming their adult children, a lot of times, they're very busy. They might have young kids, busy jobs. So it can be helpful for your agent to have someone else who can share the burden of the work. But again, it depends on their relationship. When we're doing this, we also explain it's important that they each have independent authority to act. If you're requiring joint decision, it can be very difficult because again, people have busy lives. If they're required to go to the bank together and do everything together, sometimes it's more of a burden, and it's better just to name one of them and have the other be the successor agent. So, whether or not you have co-agents, you always need to have a successor agent named. You don't know what's going to happen. You should always have a chain of command planned out. So, sometimes people have an initial agent and a successor, and then sometimes even a third option or fourth option. If you have people to name, it's always good to have, multiple levels just because you never know what's going to happen. The next slide is on common mistakes to avoid. I've touched on some of these already, but I can't stress enough just to choose the right person for the job instead of making these common mistakes. The common mistakes are naming the oldest child automatically. So they're just used to always going to that adult child. And so without even thinking about the characteristics that are important, the oldest child is just automatically named. And sometimes that can also feel like a burden that they're always the one who's responsible. The second is choosing someone out of guilt. Again, oh, my child will feel bad if I don't name them, so I will just do it. No, no, no. Again, choose someone who is right for the role. Not updating your documents as family situations change. You sometimes people have the approach where you set it and forget it. You did your documents, you don't think about it anymore. Um, you really have to pay attention. I had someone recently, the executor was a sister, who had dementia, was in a nursing home. So luckily there was a co-executor, but even so, it was difficult because we had to get a renunciation and we had to go through a medical renunciation, and we had to go through all this process, even though she'd been in a nursing home for, I think, 10 to 12 years. So he definitely could have updated his documents in that time. So as your family situations change, make sure that you look at your documents to update them. The other mistake is not talking to the people you've named to let them know. You don't want them to be surprised. You don't want them to find out once you pass away or once there's a crisis. Talk to them, see if they're willing to serve in that role. Another common mistake is choosing someone who will not follow your wishes. You don't know if someone's going to follow your wishes if you haven't had the conversation. So you need to make sure that you've expressed that to them. And then finally, keeping your documents where no one can find them. This comes up a lot, actually. People immediately think, oh, I should put these in my safe deposit box. No, you should not, because no one can access that. So you want to keep them in like a fireproof, waterproof box or bag in your house that's accessible, and tell your agents where the documents are. Sometimes people give their agents a copy. You can. That again depends on, do they need to act now, or is it, is the potential they might not need to act for years and years. At a minimum, you should let your agents know you did your estate planning and where you keep those documents. Um, I had a funny situation where a client, the power of attorney, she didn't need anyone to act. It was going to be years, but she wanted to do the documents. And she said, well, what if my agents break into my house and steal my documents? And I said, if you're worried about your agents breaking into your house and stealing your documents, that is not the right choice for your agent. So, I mean, that's extreme, obviously, but your agents need to know where the documents are and how to access them so they would be able to act. Next is when to update your choices. So, you should really review your documents every 3 to 5 years at a minimum. Like I said, people kind of view estate planning as set it and forget it. And most times, when people come in, they did their documents when their kids were little or when their first child was born. They wanted to set up a will so they could appoint a guardian. Don't look at the documents for 40 years. Now they come back and their kids are adults, they have grandchildren, and everything's completely changed. So every 3 to 5 years, take a look. And then also, whenever there's a major change in the family, such as a marriage, divorce, death, an illness or diagnosis, retirement, a move to another state is one. If your documents are valid where in the state they're created, they're valid in any of the 50 states. However, you should still, if you move, talk to an attorney in that state because there could be different laws in terms of the estate administration. So it's worthwhile to have a meeting to discuss that. Also, a change in family relationships or when children become adults and are responsible enough to act as fiduciaries. When your kids are little and you might name a neighbor or a friend to serve as your financial power of attorney or healthcare agent. And most people, if their kids grow up and are responsible adults, that shifts and they want their kids to be able to act as their agent. So, that's something else to consider. Also, a change in financial situation. Sometimes that change requires an update to the document, sometimes not, but that is always a time where you want to look at your documents and make sure everything still works for you. Again, have the conversation. Make sure your agents are okay with serving before you complete your documents. You don't want to do all the work, do all the planning, and then you talk to someone and they maybe have things going on that you didn't know about and they're not comfortable serving as your agent. So talk to those people before you complete your documents. And then after you're done, after you've done the work and your documents are signed, update your agents on where the documents are located. You should also be having continuing conversations with your healthcare agents about your healthcare wishes. So it's, a continuous thing. You're going to keep checking them, keep updating your agents to make sure that your estate plan still works for you. So really, in summary, when choosing your agents, you want to ask yourself these questions. Do I trust this person completely? Will they follow my wishes? Can they handle the pressure of serving as your agent? Are they available? Are they able to take on the work of serving? Will they communicate well? Do they understand their responsibility? Do they understand what they're taking on? And would they ask for help if needed? So, you want an agent too who will go to a lawyer, go see a professional if they're not sure what to do. I mean, that is also an important part of being an agent. So, I hope that in the 31 minutes, I hope that I've convinced you why thoughtful planning matters and why, if you haven't done your estate planning yet, why you should do it now, or if you've already done it or maybe it's very old, why you should update it. By doing the planning, I know it's not most people's idea of a good time, but you are protecting your wishes, you're reducing family conflict, you're preventing confusion and delays. You're making emergencies easier for your family to manage, and you're giving your loved ones peace of mind. If they know you've done your documents, it's a huge relief for them. And I'll end with this. I had married couple. The husband was extremely resistant to executing a complete set of documents. He basically wanted to write his will on a napkin and be done with it. He just kept saying, I just want it to be simple. I just want it to be simple. And we were going through the process, and he was just resisting. His wife was the one who convinced him to so that we needed, they needed to do this. And it was very rewarding because truly by the end of the process, he realized that what makes it simple for his family and for his kids is having a complete set of documents with everything laid out in black and white, and the fiduciaries are chosen. So, it seems like can seem daunting. It can seem like a lot of work, but by you putting in the work and getting this all done, it is so much simpler on the back end for your family. So I would encourage all of you today to make sure that your estate planning documents are in place and that they make sense for you. If you're not sure, we can have an appointment and review all of your documents. Sometimes they don't need updated, sometimes they do, but that's something we're happy to do with anyone who wants to review their documents. So thank you for logging in today. I'm happy to answer any questions if we have any.
Looks like we don't have any.
All right. Well,
If you
thank you.
did, if I two participants raised their hand. If you do have a question, just please just type it in the Q&A. I'll just give you a second to do that if you do have any. Here we go. Are there any concerns with out-of-state agents?
Yeah, that's a great question. Yes and no. So generally with technology being the way it is, no. If the best person for the role is out of state, that's absolutely fine. Are there some times where it's convenient to have someone local? Of course, but we can always work with out of state agents. We even have, agents in South Africa and Europe. So, again, it's more important to choose the best person and not so much of where they're geographically located.
Okay,
Any other questions?
let's see. I don't have anyone to serve as financial power of attorney. What should I do?
Yeah, and we see that we have solo seniors or people who aren't solo, but their kids or other family members just aren't able to serve as power of attorney. We have professional contacts who we don't have any kind of financial relationship with any of these people, but we have had clients use them in the past who are professional fiduciaries who you can basically interview, meet with them, and see if they're a good fit for you, and they're able to serve as financial power of attorney. And again, that is a much better option than waiting until there's an emergency and then the court getting involved. So we have people who can do that.
Are there any skills and experience for trust agents?
So it depends on the type of trust. With special needs trusts, a lot of times people don't feel like they have the capacity to serve in that role. And there are different nonprofit organizations who will serve as a corporate trustee for special needs trust. For non-special needs trust, you can find professional fiduciaries. I'm not going to lie, it's expensive. So a lot of times people don't want to do that and instead will name a family member as trustee. And again, it's the same qualities that are important as with your financial agent, someone who's very organized, someone who's relatively financially savvy, and also someone who will ask for help, will go to the accountant and make sure the trust or tax returns are getting filed, things like that. So, it's very similar to a financial power of attorney.
Are there any real estate capital gains issues regarding sales?
So there can be, yes. Again, it depends on the situation, the exemption. So yes, that can be an issue when there are real estate sales. Absolutely.
Does Anderson Elder Law ever serve as a POA?
No, we don't serve as a power of attorney. That's where the professional fiduciaries come in that I mentioned. We work with professional fiduciaries. So if, for example, we had a client who is going to a nursing home and they have a professional fiduciary, we will help with that process, but we won't serve as the power of attorney.
I think you probably answered that for can these firms act as executors as well as financial power of attorneys? Um, we don't specifically.
We
Um,
don't specifically, but again, the same companies that act as financial will also often serve as executor as well.
and then does your financial POA need to be licensed in your state of residence?
No.
Okay, I think that's it for right now. Any other questions? If anybody has them that they think of after the webinar, you can always email info@andersonelderlaw.com. We'll be happy to answer any questions you have regarding this subject. We also have our next webinar that's coming up on September 24th, so please keep an eye out for that. We were happy that everyone joined today. Thank you very much. Have a wonderful rest of your afternoon and rest of the summer.
All
Thanks,
right.
everybody.
Thanks so much. Bye.